All right, if everyone please take their seats. If everyone please take your seat, we're going to begin the meeting here. Just a moment. All right, if everyone please sit down. Hey, Chairman Reagan, how you doing? Good to see you. Yes, sir. Larry Scroggs here. All right, everybody please take your seat. All right, we're going to begin the meeting here. All right, this is the Tennessee Advisory Council on Workers' Compensation, and we commenced this meeting on the 27th of February, Thursday, about 1 p.m. in the Cordell Hall Office Building in Nashville, Tennessee. I want to welcome everybody who's here in attendance at the meeting and those who may be watching the video. I'm David Lillard, Tennessee State Treasurer, and I chair the Advisory Council, and I want to welcome you to this meeting. I'm going to ask Mr. Larry Scroggs, our Executive Director, to call the roll of the Council.
Thank you, Mr. Chairman. Chairman Lillard.
Here.
Dale Cantrell. Carrie Dove. Here. Bruce Fox. Here. Brian Hunt. Here. Brian is with us by telephone. Thank you, Brian. Bob Pitts.
Here.
Paul Schaefer.
Here.
Joy Baker.
Here.
Jason Denton. Jason has been with us by phone also. Sandra Fletchall. Dr. Keith Graves. John Harris.
Here.
Terry Horn. Lynn Lawyer. Dr. Sam Merle.
Here.
Greg Ramos.
Here.
Misty Williams. Here by representative, right?
Here by representative.
Okay. Senator Paul Bailey. Representative Clark Boyd. Commissioner Mainda, by designee Mike Shinnick is here. Administrator Abby Hudgens. And we also have Troy Haley with us from the Bureau of Workers' Comp.
Here.
Mr. Chairman, you have a physical quorum.
Okay. As we noted, I believe we have 4 advisory council members on the phone. Is that correct?
Yes.
Okay. All right. And we have, for those who are new to the operations of the Advisory Council, I'll just quickly go over that the Advisory Council is established by statute to render advice to the General Assembly about bills affecting workers' comp in Tennessee that are referred to the committee. And there are 6 voting member positions, actually 7, including me, on the council. The chair by statute only votes on administrative and procedural matters, so I do not have a vote on substantive matters as to recommendations on bills. For those of you who may not be familiar with that procedure, we have 4 voting members here today. On the employer side, we have Mr. Bob Pitts and Mr. Kerry Dove to my right, and to my left, to the employee side, we have Mr. Bruce Fox and Mr. Paul Schaefer. There are 2 members that are absent today who are voting members. Oh, Brian Hunt's on the phone. Okay, we have Brian Hunt on the phone. So we have 5 voting members total that are participating today. And the remainder of the members of the council are non-voting members of the council. They, of course, express opinions on bills and engage in debate on them, but they don't have a vote on the recommendation of the council. So that's a little bit about our background and our procedure. And we'll begin by the agenda here. Do we have minutes to be approved today? All right, we have the minutes of the previous meeting, October 10th, 2019. Do we have any discussion on those minutes? All right, seeing none, Chair would entertain a motion with respect to the minutes.
Move that they be approved.
All right, do we have a second? All right, we have a second. Seeing no debate, let's see, we'll need to call the roll since we got members on the phone here. So would you call the roll of the voting members on that motion to approve the minutes?
Thank you, Mr. Chairman. Chairman Lillard, this is on the minutes. Chairman Lillard.
Aye.
Dale Cantrell, I'm sorry, he's not present. Carrie Dove.
Aye.
Bruce Fox.
Aye.
Brian Hunt.
Aye.
Bob Pitts.
Aye.
Paul Schaefer.
Aye.
Motion carries, sir.
Okay, it's adopted. All right, next item is new business, and the first bill to be considered today is HB 2101, Senate Bill 2761 by Representative Russell and Senator Bell. It allows RNs and PAs to be included on position panels. Representative Russell, you're recognized, and we welcome you to the Advisory Council.
Thank you, Chairman, and thank you, Council. What House Bill 2101 seeks is to allow physician assistants and advanced practice registered nurses to be listed on workers' comp medical panel, determine causation, and assigning impairment ratings. There are three components of this bill. Currently, you have three physicians listed on the panel. In some rural areas, it is very difficult to get three physicians to do workers' comp cases. In many cases, they're having to go outside the community and sometimes outside the county to find physicians. This bill would allow PAs and APRNs to be listed on the medical panels provided to injured employees. Many PAs and APRNs are already caring for these patient population as their collaborating physicians delegate the medical care for injured workers to them. Insurance representatives will tell you at least 50% of the cases are seen by a PA or APRN. Allowing PAs and APRNs to be listed by name will bring transparency to the process. Additionally, allowing PAs and APRNs to be listed on medical panels expands choice for injured workers and increases the numbers of providers available to care for these patients. This bill would also allow PAs and APRNs to determine medical causation in the majority of cases. Determining the medical causation is pretty cut and dry. In cases involving more complex injuries, patients are typically referred to specialists to continue treatment. Allowing PAs and APRNs to determine causation of those clear-cut cases will expedite the process for injured workers. Finally, the bill will allow PAs and APRNs to assign permanent impairment ratings. The Bureau currently uses the 6th edition of the American Medical Association Guide to the Evaluation of Permanent Impairment. Many physicians complete training programs on these guidelines. PAs and APRNs would be able to complete these courses as well in order to perform these tasks. Some have expressed concerns that the bill opens the door to PAs and APRNs performing these services with no physical oversight. However, that's not true. There is nothing in this bill that changes the practice acts governing PAs or APRNs. The activity outlined in this bill must adhere to the guidelines laid out in the respective practice acts, which includes collaboration with a licensed physician. I believe that these changes to workers' compensation program will expand access to care for injured workers and expedite the process for them that they receive the benefits to which they are entitled. If you have any questions, I have representatives from the Tennessee Academy of Physicians Assistants and Tennessee Nursing Association to answer any questions.
Okay. Thank you, Representative Russell, for that presentation. I see we have questions of the representative regarding his bill. Any questions? Yes, ma'am.
Is that what? Okay. I would like to ask you what the definitive scope of practice is for PAs as well as nurse practitioners, and whether this will affect them reporting through a physician.
Okay, let me defer that to our physician's assistants that are here in the Nurse Association,
Okay.
if it's all right.
That's fine. Very good. Come on up. Just indicate your position and your name and
Hi, yes, I'm Catherine Moffett, the Executive Director for the Tennessee Academy of Physician Assistants.
And I'm Tina Girardi. I'm the Executive Director of the Tennessee Nurses Association.
okay.
And to answer your question, so the current scope of practice for physician assistants is they do work in collaboration with a licensed Tennessee physician. And their scope of practice is outlined in a written protocol with that physician. This bill would make no changes to that. They would still need to work with a licensed physician, and these tasks would still be delegated by the physician into the written protocol.
Okay. Yes, sir. Mr. Ramos.
I can see some merit in the bill in light of providing more timely medical care to injured employees. But I've got a lot of concerns. Under current practice, the reality of the situation is that many times employees are seen by physician's assistants or nurses, APRNs. but under the direct supervision and the ultimate responsibility of the authorized treating physician. I mean, that's
And this bill would make no changes to that. They would still be overseen by that licensed physician who's practicing in occupational medicine or.
Then why do we need this bill if it doesn't make any changes, as you say?
Well, it doesn't make any changes as far as the oversight from the physician. What it would do, it would allow the PAs and APRNs to sign the medical causation forms and also the impairment rating forms.
That's a big change. That's a major change.
It is a big change, but they would still be doing that under the supervision of a physician. They would not be doing it independently.
Why would the physician, the authorized treating physician, be required to sign off on those impairment rating and causation determinations?
Not under this current bill.
Why not? I mean, where is the logic in that, with all due respect?
We believe that PAs and nurse practitioners are competent to be able to perform these tasks in collaboration with a physician.
Is there any specialized training that the PAs or the APRNs have in impairment rating, and making impairment ratings and making causation assessments?
Well, that's
a major issue in workers' compensation.
And as far as the impairment ratings, as Representative Russell mentioned, many physicians are not required to receive training on the 6th edition of the AMA guidelines, but many do seek out those certifications in order to understand the guidelines. And there's no reason why a PA or a nurse practitioner could also not complete those courses and be able to competently perform the impairment ratings.
But those impairment assessments and causation determinations are made against the background of the physician's training as a physician.
Understandable,
Which
but-
is not the same for APRN or a PA, isn't that correct?
No, but what I would say is that your PAs and nurse practitioners are trained by their collaborating physicians in their particular scope of practice. And you have PAs and APRNs doing very complex medical tasks already across the spectrum of medicine. You've got PAs working in critical care units. You've got, PAs harvesting veins. You've got, them doing many complex tasks. Do they do that on their first day of work? Of course not. Would you expect a PA to do this on their first day of work? Probably not. They would need some training from their collaborating physician in order to be able to competently perform these tasks.
Under the current workers' compensation law, the opinion of the authorized treating physician regarding causation is entitled to a presumption of correctness under the law, under the workers' compensation law. Would that also apply to APRNs and PAs pursuant to this bill?
It would.
Okay.
Thank you.
Any other questions from members of the council? Yes, ma'am. Ms. Hudgens is recognized.
I have one question, and then I have a couple of concerns I want to share with the advisory council. When you talk about a PA or an advanced practice registered nurse, you said that they are under the oversight of a physician. When we talked, when you all came to our office, it seemed like there was a wide variance. Sometimes that they would only come to the office where the PA was once a month to review records. How does that square with Mr. Ramos's concern that there be active oversight of the PAs and nurse practitioners?
Well, under the statute, it requires the active oversight of the physician, but it does not require them to be physically present at all times. So depending on the structure of the practice, there are some practices where the physician is in an exam room right next to the PA every day of the week, all day long. There are some practices where the PA may be practicing in a remote site. Perhaps the physician is in an urban area, and the PA is staffing a rural clinic that's tied to that practice. And under the statute, they are required to visit, the physician is required to visit the clinic a minimum of once every 30 days.
That's where my concern lies. That seems to be a very long period of time. Let me just say that couple of the consequences that I'm concerned about of the bill, and one is that all three physicians on a panel could be a PA or nurse practitioner. And if that were the case, there would be no physicians available to the employee, which would be a real change from the system that we've come to expect from workers' compensation. And they would have no rights to get to an actual medical provider. So that's one concern. The other concern is one Mr. Ramos touched on, and that is the presumption of medical correctness, and that being provided, given to the chosen provider. And it's an important element. It's sort of the linchpin of all work comp cases. And it was part of the 2013 reform and was meant to reduce the time and meant to reduce doctor shopping. It's my expectation that if this bill were to be successful, it would increase medical cost and add additional time for claims as opposing sides. If they didn't like what the PA or the nurse practitioner opined, they have a real incentive to try their hand in court with an IME from a medical provider on issues of causation, maximum medical improvement, the impairment rating, and that whether they're able to overcome the presumption, I think there would be a lot of litigation trying to overcome that presumption. The other thing is with the possibility that the collaborating physician would only have to be, they have to be there at least, they have to touch base at least every 30 days. It's hard to see how causations, maximum medical improvements, impairment ratings can get the appropriate review. And if they do, that's building all that time into the process. And the one thing we've tried to do with workers' comp is to make it speedier. I have a great respect for PAs and advanced practice registered nurses. I think they have an important role in providing access, but this legislation causes me a good bit of concern. They don't have, they haven't been to medical school, they haven't had an internship, they haven't had a residency, and all that provides knowledge on their part that I think cannot be transmitted to a PA basically just on the training of their collaborating physician. While you all have talked about there would be all this collaboration, the law does not really give much specificity to the amount of oversight. And to me, that is a leap that should be looked at very carefully, and I have concerns about that.
Okay, any other questions? Mr. Ramos, I recognize.
Go ahead.
Dr. Merle,
Okay, yes, Dr. Burrow.
and if I may, I have some concerns about this, and I echo how you have some concerns, but I want to point out that it's not just a matter of adding nurse practitioners and PAs as providers to a panel. You're essentially asking that we redefine what a healthcare provider is based under the Workers' Compensation Code. And it's clear in the language of the existing code that it did not envision nurse practitioners and PAs as leading a team of healthcare providers. I'm a physician. We have nurse practitioners and PAs in our practice. We actually actively engage in the teaching and instruction of nurse practitioners and PAs. I also have medical students that come through. And I will tell you that the level of preparation, as well as the expectation and what they are being trained to ultimately provide to patients is very different. And it's not fair to our injured workers for them to be able to expect the same thing from a nurse practitioner and a PA as they do from a physician. I also have concerns about apart from the work comp setting, about how well physician oversight actually does take place. And again, I think that that is a concern in the work comp system. Additionally, I'm not certain that just by passing this bill that you can say that a nurse practitioner or a PA is qualified to place someone at MMI or a time impairment rating. And certainly, I have some concerns about their ability to determine causation. You seem to think that they could go to a weekend course, but it's much more than just being able to take a guide. It's really having the breadth of experience, not just in care as injured workers, but also how that fits into the whole background of their health in general. It's akin to saying that they are harvesting a vein, as she pointed out. That's not the same thing as harvesting the vein and then doing the bypass surgery. You know, the cardiothoracic surgeon has delegated him to harvest the vein, but he would not feel comfortable, nor would a patient expect that that PA or nurse practitioner is going to then perform the cardiovascular surgery. And as has been pointed out, the training is very different. You know, there's estimates that there's 1,000 hours of training that a nurse practitioner goes into before they receive their degree. But compare that to the 20,000 hours that a physician receives. And to point out again, once you have your degree, there is no residency program for a nurse practitioner or a PA. In the case of a physician, they essentially, before they can get a full medical license, have to pass their board as well as practice for a year in the state of Tennessee and not just be a trained physician. Additionally, in the case of workers' compensation, most of these cases are handled by orthopedists or neurosurgeons, or at least the vast majority of them, especially in complicated cases. And those physicians have gone on and have an additional 5 to 7 years of training. And not only have they been passed general boards to become a physician, they've taken written boards as well as oral boards in a subspecialty setting. So I think if you talk about transparency, it's very misleading to say that the education and preparation would be the same. Also, you talk about the ability to use the AMA guide from a sick physician. If you actually read the AMA guide, they clearly talk about the treating physician, not the treating healthcare providers. Because as we all know, along the way, there are many healthcare providers involved in the care of a patient, whether that be a work comp patient or just a non-work comp patient. At the end of the day, it seems as though this is increasing the scope of practice, the scope of practice. And while you say it doesn't change the scope of practice laws as they are for nurse practitioners and PAs, you are in a sense doing it in asking the work comp system to be a beta testing ground to expand that scope of practice. And I really think that that's something that injured workers in the state of Tennessee really don't deserve.
Thank you, Dr. Burrow. Mr. Ramos, did you have a follow-up question?
I just had a couple of follow-up comments. I have all the respect in the world. I don't want to be misunderstood. I have all the respect in the world for PAs and nurse practitioners. But from an employee standpoint, this really changes the whole scope of workers' compensation. We talk about that grand bargain where employees give up the right to be able to sue an employer for any kind of negligent conduct in exchange for a certain schedule of benefits. And now with that dwindling monetary benefit, the medical care and treatment, including lifetime medical treatment under our workers' compensation law, becomes even more important than ever. That's number one. But from the employer side, and Dr. Merle raised all those points in an excellent fashion. But from the employer side, as Administrator Hudgens has mentioned, I think an employer should be concerned that our litigation is going to increase because claimants now are going to have a better reason and probably a more challengeable case, a better case, I should say, to try to rebut the medical opinion of a PA or nurse practitioner, and that's going to end to longer litigation, more cases, more litigation, in fact, and that'll increase the cost of workers' compensation in general for employers. So I think both employees and employers have legitimate concerns, or should have legitimate concerns about this bill. That's all I wanted to say. Thank you.
Thank you, Chairman. I have a question, Representative Russell or ladies testifying. Is there any data from other states that have done this, and the states that are allowing this, have they already settled this scope of practice debate? I mean, are there states that are changing their language to match this, but the PAs and the nurse practitioners are still working under the supervision of a doctor, or in those states has the scope of practice shifted to where they don't have to have any supervision?
To speak for the PAs, there are several states out there that do allow PAs to perform these functions. They are not, they're not listed necessarily in the statute as a treating provider, but there's also nothing in the statute that limits that treating provider to be a physician. As far as data, I do not have that, but I can certainly see if there is. But there are PAs out there that are working with physicians that have delegated this in other states to perform those functions.
Sorry.
Do you have any members of the public who wish to comment on this bill? Thank you very much.
Please. All right, we're in the section of discussing, yes, sir. Yep, this gentleman over here. Please state your name and position, if you would, please. Yeah.
Am I on?
Yeah,
There we go.
there you go.
Good afternoon, Mr. Chairman and members of the council. My name is Yarnell Beatty, and I'm a vice president of the Tennessee Medical Association. And we are here on behalf of the 9,500 members of our association in opposition to this bill. We have significant concerns and questions about it if it were to pass. With respect to the inclusion of employers, of PAs and nurse practitioners on the panel of three employer providers, it really only the bill only allows that to happen if only two things happen. First of all, if the nurse or the PA takes the certified course on the guidelines, the sixth edition of the AMA guidelines, and can find a collaborating physician who's willing to allow that to happen via written protocols. So really only two things that have to happen. Dr. Merle has done a much better job than I ever could in delineating the educational levels between a physician and PAs and nurse practitioners, so I won't go into that. We're very concerned that the bill would allow that panel to be comprised solely of nurse practitioners and PAs if the employer so chose. There's three problems with that, at least three problems. Number one, that the worker might be denied a higher level of care from a physician. Number two, if the collaborating physician happened to see the patient during a visit instead of the PA or nurse practitioner who was on the list, would that mean that the employee would be responsible for paying for that visit? It's an unresolved question. And employers might intentionally provide a panel of just APRNs or PAs thinking that it would reduce costs, when in the long run it could actually increase costs. Currently, when, well, I talked about the education. Under current law, there's a presumption of medical necessity and the correctness of the panel chosen provider's recommended treatment. The bill would give that presumption to the APRNs or the PAs, even if there was an experienced physician who disputed the medical necessity of the recommended treatment. Now, for those of you who practice law on this council, it would be like having your paralegal have the presumption of correctness in a legal decision. You could overcome that, and probably would if you're a lawyer, but why go through that exercise at all? It just doesn't make any sense. With respect to the assignment of the impairment rating, and I believe that the bill also would allow nurse practitioners and PAs to determine maximum medical improvement. At least that's how I read it. The AMA guidelines do not list APRNs or PAs. Of the contributors, which there are over 100, there was only one that had RN. The rest were physicians. Under the current law, and not changed by this bill, there's also a presumption given to the provider chosen on the provider's opinion on causation and ratings, impairment ratings. So that the bill would also, not only presumption of correctness of treatment, but the presumption on causation and rating would be with the PA or the nurse practitioner, even if there was a physician that had a contrary opinion. It would invariably lower impairment ratings because APRNs and PAs would not be able to diagnose or rate the most complicated injuries, which might include surgery or multiple chronicities. With respect to giving an expert opinion on the causation of work-related injuries, if the APRN or PA provided an expert opinion on causation, couldn't the employer designate a physician to provide a counter opinion for the employer? And then would the worker's lawyer, then fearing that the court would give more credence to the physician, then have to go out and get a physician, so thereby raising the lengthening litigation and raising the cost of the workers' compensation system. So in summary, there's no guardrails in this bill with respect to experience or training. It could be 2 weeks or 20 years. There's nothing in there. If they can find a physician that would allow it and put it in protocols, it can happen. There's no mention really of the collaborating physician's role in this process. Does the collaborating physician even have to see workers' compensation patients at all? Or could the physician just be responsible or just have knowledge of the types of injuries that the PA or nurse practitioner treats? So maybe not a knowledge of the workers' compensation system, maybe not even a knowledge of the guidelines, but they could still collaborate in this fashion. For years, the nurses have asserted that they don't practice medicine, they practice nursing, which I think is important going back to the guidelines. But also there's nothing in the bill that contemplates practice of nursing. In fact, the guidelines are medical guidelines. So I think that, you know, if you're going to pass a bill that would allow them to make these kind of medical judgments, I think there's a disconnect here. We absolutely appreciate, physicians appreciate what APRNs and PAs do. They're a valuable function for the healthcare team, but I want to emphasize that it's a team, and everyone has their role, just as they would on a football team or something like that. The nurses have concurrently introduced a bill that would, if passed, would allow them to have independent practice, that is, practice independent of having a collaborating physician. So if that bill passed and then this bill passed, there would not be a requirement even for a nurse practitioner to have a collaborating physician and participate in the workers' compensation program. So for those reasons, we urge you to give a negative recommendation to this bill. Thank you.
Thank you, sir. Representative Russell, do you have any closing remarks or rebuttal for your bill?
Well, I'd like to thank the council and just let you know my goal is to make the whole workers' comp more effective and efficient. With over 50% of the workers' comp patients are already being seen by PAs and RPNs, I think this is the only way to go. And from my understanding, PAs already get 4,000 hours of training, while family practice physicians only get about 6,000, not the 20,000 that was mentioned earlier. This bill will also allow employees to keep their all physicians on their panel if they choose. So any consideration y'all can give is appreciated.
All right. Thank you, sir. All right, is there a discussion by voting members of the council at this point, or a motion with respect to this bill? Yes, sir. Mr. Fox is recognized.
On behalf of injured workers, I would move that this bill be tabled and not be approved. The concerns expressed by Mr. Beatty, I think, summarize why this bill is bad for workers' comp in Tennessee. And in addition, we have Ms. Abby raising questions about it. That should be a red flag for all of us, that this needs further discussion and consideration, and I would move that it not be given favorable.
Okay.
vote.
So just to clarify, under the statute the advisory council operates under, we can't quote-unquote table a bill. We either make a positive recommendation or a negative recommendation.
I'm making a negative
Okay.
recommendation.
Those recommendations can be made with an attached amendment. In other words, if we recommend against an amendment, but you're making a motion to recommend that I have a negative recommendation out of the council is what your motion is, right?
Yes, sir.
Okay. Our motion for a negative recommendation, is there a second? We have a second. Is there any discussion on the motion at this point? Seeing none, Mr. Secretary, would you call the roll of the voting members on the motion for a negative recommendation on HB 2101, SB 2761?
This is on the motion for a negative recommendation. Mr. Dove? Mr. Fox? Mr. Hunt? Mr. Pitts? Mr. Schaefer? The negative recommendation motion prevails.
All right, the bill goes out with a negative recommendation. Thank you, Representative
Thank you.
Russell. All right, we're going to take things a little out of order here. I want to call up HB 2256, SB 2189 by Leader Lamberth and Leader Johnson. In part requires workers' compensation coverage for construction services. You're recognized, Mr. Leader.
Thank you, Mr. Chairman, and that's exactly what it does, and I believe we have some members here that can answer questions. If you have any additional questions, I appreciate the work of this board. I know that you all do your homework before you come in here, so I will not belabor you with a lengthy discussion right now as to what this does, but I do stand ready for any questions, and I believe Mr. Haley does as well.
All right, do we have any questions about the bill from any member of the council? All right, I don't see any questions. Is there anyone in the audience from the public that has comment on this bill for the council? All right, chair receives none. Is there a motion from members of the council, the voting members, with respect to HB 2256?
Mr. Chairman.
Do we have an amendment on this bill?
Yeah.
Say, I'm showing we got drafting code 15003, an amendment on the bill. Is that right? Just want to make sure
It's
what
in
we
the
got
folder.
before us here.
Yes, sir, Mr. Chairman, that's the amendment code I have.
Okay. So we'd be voting on the bill, including the amendment, which is drafting code 015003. All right. Okay, seeing no comments, is there a motion?
Trying to figure out how to turn this thing on.
Figure that.
That one.
Punch it right there, yeah. There you go.
Mr. Chairman, I have a motion. My motion would be that this bill, House Bill 2256, with the proposed amendment, be given a positive recommendation.
Okay, we have a motion for positive recommendation. Is there a second? Second. All right, we have a second. Any discussion on the motion? Seeing none, I'll ask Mr. Executive Director to call the roll on the motion for a positive recommendation on HB 2256, Senate Bill 2189.
Motion for a positive recommendation, Mr. Dove? Mr. Fox? Mr. Pitts?
Aye.
Mr. Schaefer? Mr. Hunt?
Okay.
Motion prevails.
All right, it prevails. HB 2256, Senate Bill 2189 goes out with a positive recommendation to the council. We'll next call up the other bill that Leader Lamberth has, which is House Bill 2257, Senate Bill 2190. Leader Lamberth, you're recognized.
Thank you, Mr. Chairman and members. Thank you for that positive recommendation on the previous bill. Again, I know you've reviewed the materials. I stand ready for questions. So does Mr. Haley. I believe, and Mr. Haley could probably best address this, I think there may be some additional changes that would be coming to this particular piece of legislation as well.
All right, and I forgot to add that in my announcement of this bill that the official on the agenda recital on it indicates that it in part revises the physician referral process. Mr. Haley, did you have remarks on the bill?
Yes, thank you, Mr. Chairman. This bill, as introduced, has various provisions that will update the 2013 Workers' Compensation Reform Act. It's my understanding that we've reached an agreement, though verbally, to amend the bill to delete sections 1 and section 4 from the bill.
And, Mr. Chairman, I concur in that in working with a variety of interested parties, including the Tennessee Chamber. They brought some concerns to us about specifically sections 1 and 4. And if this council deemed to send this out with a positive recommendation and traveling with that an amendment to remove those 2 sections, I certainly would have no objection, and I appreciate everyone's hard work on this.
Okay, any other comments, questions, or discussion by members of the council?
Mr. Chairman. Sorry, just one other question. We had sort of mentioned a study in the off-season on those 2 sections, and I don't know if we need to do anything formally or informally about that, but we just wanted to, sort of put that out there that we were interested in working with all the stakeholder groups in the off-season on those 2 sections.
Well, if that's the will of the council, when a motion is made, we would make that part of the comments that are related with the bill, that there should be a summer study, if you will. Mr. Pitts, were you seeking recognition?
That was my question. Is that part of the motion or
It would
going to be
be.
made part of the comment?
It would be a comment that goes out with the you can make it as part of the motion if you want to, but it also would be a comment, so.
Has somebody made the motion?
Nope.
Mr. Chairman, I'll make a motion that House Bill 2257, with the exceptions of section 1 and 4, be reported out with a positive recommendation.
Okay.
With the understanding that there will be convened a study group involving the business community and other appropriate officials, study the issues of 1 and 4, and come back with positive recommendations for next year.
Okay, thank you, Mr. Pitts. So to interpret Mr. Pitts' motion, he's making a motion for the bill 2257, House Bill 2257, to go out with a positive recommendation. We're traveling with an amendment to delete sections 1 and section 4 thereof, and also with the comment that a summer study along the lines that Mr. Pitts mentioned should be undertaken. We, as a council, don't have the power to order a summer study or anything, but we can make that comment to the General Assembly. All right, is there a second for Mr. Pitts' motion as stated by the chair? Second. We have a second, okay, all right. Any discussion on the motion? Mr. Ramos.
Can I ask for clarification?
Mm-hmm.
Because it sounds like section 1 is, and section 4 for now are going to be studied later. Do I understand that right?
That's our comment, that it should be, yes.
And that's really kind of the meat of this whole legislation, isn't it? Because the section 1 talks about the procedure by which a referring physician can refer someone to a specialist, and then number 4 changes that 10% to 9%. Isn't that the main part of the legislation?
Some birds have more meat on them than others when it comes through the process, but.
Depends on where you are.
Leader Lambert's recognized.
Is there anything that we should know about what's being discussed or what's being envisioned in
Let
place?
Leader Lambert explain.
Thank you, Mr. Chairman, and sir, with all due respect, I do think that sections 2, 3, 5, 6, and 7 are an important update to the workers' compensation laws of our state. I understand that they may not be as weighty or as controversial as sections 1 or 4, but I can assure you that they would still be a positive update to our statutes. And so to me, when I'm carrying a piece of legislation, it is all important. They are not as weighty as the other parts, and I would hope that you would study those and help guide us going forward on those weighty portions of this, and that we would join with the business community. But yes, sir, I would certainly appreciate it if sections 2, 3, 5, 6, and 7 would proceed, because they would be a positive step forward. That's just my humble opinion.
Okay.
Thanks for the clarification.
All right. Okay. Any further discussion on the motion that's been made and seconded? Seeing none, we'll call on the executive director to call the roll on the motion for a positive recommendation with the amendment as described and with the comment as described.
On the motion, House Bill 2257 for positive recommendation, Mr. Dove. Aye. Mr. Fox. Aye. Mr. Hunt.
Aye.
Mr. Pitts.
Aye.
Mr. Schaefer. Motion prevails.
All right,
Mr.
motion
Chairman.
is adopted, and so House Bill 2257, Senate Bill 2190 goes out with a positive recommendation with traveling with the amendment to delete Section 1 and Section 4 and with the comment as described in the motion. Thank you, Leader Lamb.
Thank you, Mr. Chairman and members of this commission. I appreciate y'all, and again, appreciate your hard work, and thank you for taking me out of order. I have a heat and air unit out at the house, and if I can get home in time to meet the repairman, we'll be good to go for this evening. Otherwise, I will literally be out in the cold, so thank y'all.
Well, we hope you get through that crisis. All right, thank you. All right, we'll go back to regular order. Our next bill is House Bill 2154, Senate Bill 2861 by Chairman Boyd and Senator Bailey. It is a bill that changes the date for the BWC report on impact of Workers' Comp Reform Act.
Mr. Chairman,
Boyd.
if it pleases you and the council, I'd love for y'all to continue going out of order so my colleagues from West Tennessee and East Tennessee can move on, because I'm going to be here the whole time anyways, if that's okay.
All right, if you'd like to do that, then that would be very gracious of you. So we'll move on then to House Bill 2577 and Senate Bill 2691 by Chairman Reagan and Senator Briggs, which creates a PTSD presumption for public safety employees. Chairman Reagan, you're recognized and welcome to the Advisory Council.
Thank you, Mr. Treasurer, and I appreciate being here. Good afternoon to everyone, and thank you to my colleagues for allowing me to shorten my time here and get back home to my family. This bill, as was noted, creates a presumption that PTSD is an actionable cause for workers' comp. Very briefly, let me give you some background here. A 2017 Rudderman Institute study indicated that first responders die by suicide, more first responders die by suicide than in the line of duty. In fact, 93 firefighters, 129 law enforcement officers have been suicides in 2019. 103 firefighters, 140 law enforcement officers in the same category. Medical research has indicated there's a clear connection between the exposure to critical incidents and poor mental health, sometimes physical as well. A 2015 FSU study found that 47% of firefighters have thought about suicide, 19% have created suicide plans, and 15.5% have attempted suicide. A 2013 National Institute of Occupational Safety and Health found firefighters 14% more likely to develop cancer, in which the mental condition have been a contributing factor. Brain scans, and by the way, I have to confess that my colleague in the Senate, Dr. Briggs, was going to be here, but unfortunately he's on call and had to leave. So I will ask you to treat these comments as from a layman, but he sent me these talking points. Brain scans show evidence-based changes in the structure and function of the brain. In other words, PTSD is a brain injury. On the bill itself, essentially what it does is allow an avenue for an emergency responder to be able to be diagnosed by a mental health professional with PTSD and seek treatment. I have personal experience with this. I spent 24 years in the military and in fact was an accident investigator for 5 of those years. Have personally had the opportunity to pick up body parts of my colleagues, and I can tell you that PTSD is a very real thing. I saw it in the units I commanded, and I saw it in my colleagues and my friends. It is a reality, and our first responders are exposed to some of the same things that our military personnel are exposed to. With that, I humbly request a positive recommendation.
Thank you, Chairman Reagan. Are there any questions to Chairman Reagan about his bill here from members of the council? Questions or comments? Okay. All right, yes, ma'am. Ms. Baker.
Every day, our public safety officers risk their lives to protect the citizens and our communities. They display exceptional courage in the attempt to protect human life and our property. They work in very difficult environments and under the most challenging of circumstances, and we are very, very thankful for their bravery and their sacrifice. As we consider this bill, there are some issues that we would hope that you would take into consideration. Under the existing law, workers can seek workers' compensation benefits for PTSD when the injury is work-related. This bill would undermine that key element in the workers' comp process. This is an unfunded state mandate, which could place a heavy financial burden on our local entities. These additional cost burdens could result in property tax increases and/or cuts in critical programs and staff. What we would like to see is a state-funded and administered program to provide benefits to our public safety officers, a program that would provide them with the assistance they need while still maintaining their privacy. Thank you, sir.
Thank you. Thank you, Ms. Baker. Any questions? Further, Chairman Reagan, did you wish to respond?
Yes, thank you, Mr. Chairman. I will point out that in the first paragraph of the bill, it says that it is compensatable under workers' compensation as compiled in Title 50, Chapter 6, unless it is shown by preponderance of evidence that the post-traumatic stress order was caused by a non-service connected risk factors or non-service connected exposure. Therefore, it is directly related by virtue of this bill to that which occurred on the job. The bill further excludes any mental condition resulting solely from a disciplinary action, work evaluation, job transfer, layoff, demotion, termination, or similar action taken in good faith by an employer that is not considered an injury in the line of duty, according to the subsection I just referenced. I hope that addresses your concern. As far as the compensation piece, I can certainly work on bringing another bill for state compensation. However, I would point out that the firefighters, the police officers, the EMTs that are in our local communities are providing an essential service to our local communities. In fact, it's unparalleled. Many of our firefighters, in fact, the majority of them, are volunteer firemen. They do this out of a sense of duty. I think it's unrealistic to expect the communities to be not responsible for covering some of the injuries, and this is truly an injury, that these personnel experience during the service. Thank you.
Thank you, Chairman. All right, any further comments or questions by members of the council? All right, seeing none, is there any comment by any member of the public who is present today on this bill? All right, seeing none for the record there. All right, Chair would entertain any motions with respect to HB 2577, Senate Bill 2691. Mr. Fox.
I'd first like to thank Representative Reagan and Senator Briggs for bringing this to council, and I would move that we give it a favorable
Okay.
approval.
Motion is for a favorable recommendation. Is there a second for that motion?
Second.
All right, we have a second for that motion. Is there a discussion on the motion? Motion is for a favorable recommendation. Mr. Pitts is recognized. Turn on your mic. There you go.
Mr. Chairman, I'd make a comment. I'm obviously not going to be for this recommendation. I believe since there's been an advisory council, I don't believe there's been a bill before the council. It may have gotten before the legislature some other way, but if I'm correct, any bill that is passed giving a presumption for anything, and frankly, that's my problem. I would like for us to have a workers' comp law that's predicated on a finding of fact in each and every situation without the creation of presumptions that in effect automatically grant benefits without a cause and effect relationship.
Are there any further comments or discussion on the motion that's been made and seconded? All right, I'll ask the executive director to call the roll on the motion, which is a motion for a favorable recommendation on HB 2577, SB 2691.
On the motion for favorable recommendation, Mr. Dove?
No.
Mr. Fox?
Aye.
Mr. Hunt?
Opposed.
Mr. Pitts?
No.
Mr. Schaefer? The motion fails.
All right, the motion fails. Under our statute, a motion must receive a majority vote of the voting members, so that motion would fail. I'll ask the members of the council if they have any further motions to be made with respect to this matter. Any further motions on HB 2577?
I have a question.
Yes, sir.
Mr. Pitts, if it created a rebuttable presumption, would you be able to support an amendment?
I don't think so, because I still think it puts it on the other side. You win unless it's overcome. And I like equality in the marketplace.
Mr. Chair, could I be
Yes,
recognized on that?
yes, Chairman Reagan.
I will point out that in the first paragraph of the bill, that it says, unless it is shown by a preponderance of the evidence, that it is not caused by the non-service connected factors. I would submit to you, based on my experience in the military, which was 24 years long, and having observed this phenomena, that, again, it's not a case of proving it. It should be a case of saying it's there unless you can find it's not. Thank you, sir.
Thank you, Chairman. All right, any further motion with respect to this legislation? All right, if there is no further motion, the chair rules that it goes out without a recommendation. We don't have any authority to kill or hold a bill, so it would go out with no recommendation.
Thank you, Mr. Chair
Chairman
and
Reagan.
committee. I appreciate your time and effort. Thank you to my
Chairman.
colleague for allowing me to step
Okay,
in.
very good, thank you. All right, next item is HB 2628, Senate Bill 2404 by Representative Thompson and Senator Kyle, and it's to revises penalties for noncompliance with workers' compensation coverage. Representative Thompson, welcome to the Advisory Council, and you're recognized.
Thank you, Mr. Chairman. It's my first time here, and I want to appreciate you listening to me, and especially want to give my appreciation to Chairman Boyd. I've got 2 meetings this evening in Memphis, so I need to get on the road pretty soon. Okay, this we call this bill the Protecting Honest Contractors Act. We began working on the bill after we read the Bureau's annual report on misclassification. It shocked us to learn that how dishonest contractors and labor brokers were breaking the law and cheating taxpayers. And even worse, they were stealing business from honest contractors who are following the rules. We believe that hardworking Tennessee business owners should not have to compete with companies and brokers that ignore worker comp rules and misclassify full-time employees as independent contractors. There should be swift consequences for dishonest contractors and brokers. And unfortunately, as the report shows, these bad actors are hard to catch. Dishonest brokers are ignoring investigations and fines, and when the work is done, they often leave town, often forever. In workers' comp investigations, the passing time is not our ally. So our goal with the Protecting Honest Contractors Act was to provide the Bureau with a new tool to compel compliance on the front end of a job. And the stop work order mechanism in our bill could have been issued urgently when investigators found evidence of noncompliance. Since we filed the legislation, we've had excellent discussions with stakeholders. We've talked to the Labor Department, Insurers of Tennessee, Associated Builders and Contractors, the Carpenters, members of the Associated General Contractors of Tennessee, the laborers, and unaffiliated small business owners. We've also learned that workers' comp laws are tricky. These rules need thoughtful input from all stakeholders to be effective. But the bottom line, everybody shares in our core concern, and honest contractors deserve a level playing field. The new fair enforcement mechanisms are needed. In the General Assembly, you know, our next step is usually ask for a summer study, but we understand that the Advisory Council may work a little bit differently. And therefore, today, instead of a recommendation on our bill, we're requesting that members of the Advisory Council make a motion to establish a working group that would study new workers' comp compliance enforcement mechanisms and make a legislative recommendation for the next General Assembly. Our hope is that the study would explore all reasonable enforcement options, including elements of our bill, but certainly not limited to it. We would also ask that this working group be fairly comprised of industry stakeholders on all sides of the issue and appropriate state officials. And finally, we ask that we lawmakers be notified of the meetings so we can continue learning more about this important issue. In summary, we want to thank everyone who's met with us, who has worked with us, and for all of you who share our vision to protect honest contractors in Tennessee. Thank you.
Just for clarification before Mr. Pitts speaks, you're saying you're not going to run the bill this year? Is that your current intention?
That's correct.
And you want to just do a study? Is that what you're saying?
Exactly.
Okay, Mr. Pitts is recognized.
Chairman, I'm going to try to help a little bit with some clarification since all the parties are in the room, including the sponsor and a representative from Senator Kyle's office is also present in the room. I had extensive conversations at her request of Senator Kyle yesterday with the Workers' Comp Bureau and others, and I think everyone is basically in agreement with what you're suggesting. I believe I had permission from Senator Kyle's office for one slight modification. And Mr. Chairman, I need your input on this. We can request that the Bureau of Workers' Comp could provide the supervision for such a study. It'll be up for them to decide it, but I believe they're favorably inclined to do so with a request from us for that to occur, as opposed to it going forward legislatively. And that there be recommendations for the next General Assembly, everything else that he said, and that the members of the working group will be determined by the Bureau to include industry representatives and appropriate state officials. I'd like to ask your sponsor if he has any problem with that adjustment to your comments.
It sounds reasonable to me. Should we ask members from the Workers' Comp Committee and possibly?
I think they're okay.
Okay. All right, so Mr. Pitts has read the terms of a request to the Bureau of Workers' Compensation to organize and conduct a study along the lines that he indicated. And I assume that's your motion, is that right, Mr. Pitts?
That would be appropriate, yes, sir.
All right, so we have a motion.
Obviously, that means it will be delayed.
Mm-hmm. Right, and we're not making a recommendation with respect to the bill itself today. Okay.
Well, our recommendation would be delayed for the study to occur.
Well,
but then we're establishing a mechanism for that study to occur.
Right. Well, I think we have an understanding with the sponsor about that, because, I mean, the statute speaks in terms of negative recommendations or positive recommendations for legislation. Doesn't talk about delaying legislation, because we have absolutely no power in that regard. So I think we'll rely on understanding with the sponsor in regard to that. But as to the request for basically a study that the Bureau would do, I assume Ms. Hudgens and others have no objection to that. She's indicating she has none. All right, is there a second for Mr. Pitts's motion? Second. We have a second from Mr. Fox. Any discussion on the motion that's been made? Is there any comment from any member of the public in regard to the motion that's been made here today? All right, seeing none, I'll ask the executive director to call the roll on the motion.
On the motion, Mr. Dove? Mr. Fox? Mr. Hunt? Mr. Pitts?
Aye.
Mr. Schaefer? Motion prevails.
All right, motion passes, and we thank you, Mr.
Thank you,
Representative Thompson,
Mr.
for being
Chairman
with
and
us today.
council members.
Please convey our thanks to Senator Kyle also, okay? All right, that would brings us to House Bill 2154, Senate Bill 2861 by Chairman Boyd and Senator Bailey, which changes the date for the Bureau of Workers' Compensation report on impact of the Workers' Compensation Reform Act. Chairman Boyd, you're recognized.
Thank you, Mr. Chairman, and there is an amendment that we brought and should have been delivered to each one of you. The drafting code on that is 015575. So make sure each of you have that. Mr. Chairman, I'm not sure how we need to proceed on this, but let me give you a little bit of background. This is dealing with the code that allows the judges to award attorney's fees when an employee has been wrongfully denied. And that is set to sunset this summer, and we would like to extend that for another 2 years, but we would like to put some guardrails in place on the amount that the attorney's fees can be. And so we've got two separate amendments.
Okay, let me clarify one thing,
Okay.
Chairman, before you go on, is for those of you who are not in the legislature all the time, drafting code the chairman referred to is down in the lower right-hand corner of the item, and it's 015575, as the chairman indicated. Just want to point out where it is, so everybody can make sure they got the right
Thank you.
version.
Thank you, Mr. Chairman. And so we actually have two amendments, and I can give you the drafting code on the other one, but the two different concepts that we're toying with, and we would like to get your feedback on it, and if you need to vote on both of them, that's fine. But one of them would set it so that the attorney's fees could not exceed 30% of what the injured employee gets. And then the other model is one that has been worked on between the business community and the Bureau of Workers' Comp, a little bit of input from me, and it would be $15,000, except I'll just read it, except in extraordinary cases when the attorney's fees not to exceed $30,000 may be awarded pursuant to this subsection if the presiding workers' compensation judge determines, based on clear and convincing evidence, that limiting the attorney's fees to $15,000 is inequitable in light of the totality of the circumstances and all factors set forth in Rule 1.5 of the Tennessee Rules of Professional Conduct as adopted by Tennessee Supreme Court Rule 8. If the workers' comp judge awards attorney's fees exceeding $15,000 pursuant to this subdivision, then the workers' compensation judge shall make specific documented findings of fact in order that detail the reasons for awarding those attorney's fees. So, like I said, we would like to extend this for 2 more years. We think this is a valuable tool. It allows the injured worker that has been wrongfully denied to get legal counsel, which in some cases an attorney might not want to take the case. But as we renew it for 2 years, we are looking at 2 different ideas. One is 30%, one is $15,000, and then 30 if the judge thinks it's warranted. So I'll open that up for discussion or questions.
Okay. So you have actually 3 amendments here that are under consideration, right? Through 2 amendments? Okay, we got 015575, and what's the other one, Chairman?
The other one that we're looking at is 015026.
Okay.
There is a third one, but disregard it.
Okay,
Those
so
are the 2 we're
we
looking
got
at.
2 that are under active consideration, okay. All right, are there any comments or questions of the sponsor in regard to those 2 drafting codes? Yes, Mr. Ramos is recognized.
I have a couple of comments. Representative Boyd, I've been practicing workers' compensation law as an attorney for over 30 years. 35 years, let me take that back, I'm losing track of my time. 40 years as a lawyer, about 35 of which have been in workers' compensation here in Tennessee. And by way of background, I've represented both employers and employees in my career. So I think that gives me a pretty good perspective from both sides of workers' compensation about the fairness of our system and actually trying to be fair, using that as our goal. the problem now is, following the 2013 Reform Act, most attorneys have gotten out of the workers' compensation market on the side of the employee I'm talking about. And that's just a reality. I still read the workers' compensation appeals that come down from within our system now under the 2013 Reform Act. I can't tell you how many times I see appeals being denied where an employee has made the appeal, but the employee is totally lost because that employee is unrepresented, and the employee doesn't even know to file a record of what went on at the trial court level, and the appeal is denied for that and a number of other technical reasons. I'm really concerned that the fairness in the whole system has dissipated, largely because employees are now unrepresented. Okay, so that, and once again, keep in mind, I've represented employers probably more than employees throughout my career. But this limit on attorney's fees, I have a problem with. One of the things that I'm seeing now, and in the few workers' compensation cases that I'm still involved in, and I'm not involved in very many because, unfortunately, it's just an economic matter, that the recoveries are small. The attorney's fees tend to be very, very small. If you're talking about 20% of the recovery, it's just not economically viable anymore for most employees or most employee attorneys, and that's why many have just gotten out of the market. But insurance companies, when they've denied benefits, don't have any limits with what they can spend to continue denying a case. And it gets very complicated. And to have a limit, number one, of $15,000, and I know that limit can be expanded under certain circumstances in your bill, but I think that $15,000 limit is just much too low. And then even if you do get out of that limit, we still have a limit of $30,000. Keep in mind that many attorneys who no longer represent employees have gone on to other business litigation, non-workers' compensation litigation, where they're able to charge on an hourly basis $350, $400, $450, and that quickly adds up. If you're fighting an insurance company with unlimited resources, that $15,000 limit will come up in no time at all. And then that attorney doesn't get compensated. What that will do is serve as a disincentive for an attorney to get back into the situation, get back in these workers' compensation cases. One of the things that I think your statute or your legislation applies to is the situation that I've been hearing about more and more, and I've experienced on a first-hand basis in one of my cases. That's a situation where a workers' compensation case has actually been settled, and the employee gets lifetime medical benefits pursuant to our workers' compensation law. But insurance companies are more and more trying to defeat that future medical benefit. And in my case that I've just had, the insurance company, even after the court approved a settlement that called for open medicals, lifetime medicals, the insurance company later on, a couple years down the road, terminated medical benefits, which required us to get back into the case. And guess what? It was very complicated to reopen that whole situation. The law requires that before we can go back to the court that approved the settlement, in this case, one of the trial courts, the circuit court, this was a case under the old law, we had to go through the Bureau of Workers' Compensation and the whole mediation system in order to basically get an exhaustion of benefits or exhaustion of remedy that would allow us to go back to the trial court. It became very complicated. And in that particular case, the trial judge, ended up giving an attorney's award of $30,000 just to undo that termination that had been guaranteed to my client in the final order of the case. So I'm just suggesting that $15,000 limit is much too small to entice attorneys to get back into the picture to do any effective good for injured employees. And definitely, I would recommend that even if there is a limit on the front end, that there not be a $30,000 limit. And I'll say one more thing. When I brought my petition for attorney's fees in the case that I just recommended, where the insurance company had terminated medical benefits, even though the employee had the right to lifetime medical benefits under an order of settlement, attorneys have to justify their attorney's fees, and they have to show the court that it's a reasonable attorney's fee. And there is a list in our ethical code that requires us to establish our experience, the difficulty of the case, the complexity of the case, and all the hours, and the judge has to review all that. And I would suggest in this legislation that is the appropriate vehicle rather than a $30,000 arbitrary limit, because each case is different. Just my suggestion. In that way, injured employees may have some effective representation. I'll make one other point, and then I'll stop. Remember, those attorneys who have left the workers' compensation field have gotten involved in what they believe is more profitable litigation or legal business, which allow them to charge those higher fees that make it economically viable to stay in the legal world. Well, an attorney to take on a workers' compensation case basically has to stop doing a case that'll bring in $350 an hour or whatever the hourly rate is. And so the attorney will be disinclined to do that even more, knowing that there's a $15,000 limit and then $30,000 limit on the at the utmost. So all of those things being said, my recommendation is to raise that $15,000 limit, or my opposition, I guess I should say, my concern is that $15,000 limit is too low, and the ultimate limit of $30,000, in my humble opinion, shouldn't be there at all. Let the court decide that, and the factual circumstances of each individual case.
Any further comments or questions? Yes, Ms. Hudgens is recognized.
I just have one suggestion that I wanted to make. When I look at other states, they have a provision in these types of legislation that clarifies, leaves no misunderstanding, that when the employer has wrongfully denied to pay benefits, that those attorney fees are paid by the employer and not taken out of the employee settlement. I think we try to do that as a general rule, but it would be good if we could avoid litigation about that point in the future.
All right, further comments or questions?
Can I ask a question? In those circumstances, Ms. Hudgens, is there a limit that, such as we see in this proposed legislation on attorney's fees?
You mean currently?
Yes.
The current legislation? No, there's not. But this is, it had a sunset. So this bill, the current bill will sunset if there's not one to replace it.
And by the way, I'm all in favor of us going beyond that sunset deadline. Thanks.
All right, but just to clarify on that point, I was going to ask about that. The current law, and Chairman Boyd mentioned this during his presentation, the current law allowing an award of attorney's fees sunsets in July of this year, is that right? So the court would have no authority to award attorney's fees after July unless the legislature extends it in some form?
Well, right? They would get the attorney's fees that are already in place, which are 20% of the permanent partial disability benefit that comes. Okay. So it doesn't affect that. That's in the law. Okay. This law that we're talking about talks about those situations where an employee has actively or has just denied the benefits. Mm-hmm. Mr. Fox was involved in that, in that legislation, he might be able to provide some additional information about that. But it did have a sunset on it.
Yeah. Mr. Fox, yeah, and this deals with wrongful denials, right? Is that right, what we have here?
Correct. And when an employer or the workers' compensation insurance carrier has wrongfully denied care, treatment, or benefits, then the employee generally has no representation, no advocate on their behalf, especially if they had no advocate at the settlement level. And that's in probably, I'm going to speculate, 80% of the cases are unrepresented. I know my practice, when I started on Workers' Comp Advisory Council, 40% of my work was workers' comp. We took 6 cases last year.
Yeah.
So there's no incentive for lawyers that do what Greg does, what I do, to jump into one of these cases when you're capped on fees and or may not get paid at all. The employee has no ability to pay a reasonable fee, and Ms. Hudgens is right. I would like to see legislation in this state that would provide that the fees are paid by, not out of the employee's award, but paid by the insurance carrier who wrongfully denied, or the employer who wrongfully denied the claim. But we've got to patch it up somehow because it's getting ready to sunset.
I was going to say, you know, it appears to me that Chairman Boyd is offering something that is a helpful point here. I realize Mr. Ramos's point and your point that it may not be sufficient, you know, and everything. It's going to be zero come pretty soon unless action is taken. Chairman Boyd, did you have a point to make?
I do. Thank you, Mr. Chairman. And currently, and that's something that Abby and I were talking about, is if it is wrongfully denied and we're seeing the attorney's fees paid, perhaps they shouldn't get the 20% out of the plaintiff's settlement. And that seems, I don't know anybody that would really object to that, and we may need to amend that, graft that into the bill, Abby. But we do have a list of what's been awarded. And, you know, most of these fall well under those numbers in attorney's fees that have been awarded from 2017 forward, but there are a few outliers out there. And so I don't think that this is just going to, by putting some cap on it, and it's not an arbitrary cap. I mean, we looked at the data. I mean, we've got it right here in front of us. And so we came up with this number, and quite a bit of thought has gone into it. And so most of these cases, I mean, all but 2 would almost be unaffected by it. But there are a couple of cases that are pretty substantial, and we just think, you know, talking to the business community, the insurance community, and just kind of, you know, studying it. So we said, you know, we've got to extend this. I mean, we believe in this statute that allows the judge to award the attorney's fees outside of the normal settlement. We like that concept. We just want to put some guardrails on it, and we want to make sure they're high enough. We don't want to set them so low that no attorney takes the case. So I would solicit any feedback or any amendment or verbiage that y'all want to put on this, because it's not beyond us to draft a further amendment to go on there. So I would appreciate any dialogue. But you know, if we extend this for another 2 years, there's going to be some guardrails on it.
Yeah. All right, let me ask at this juncture, if I could, does any member of the public have any comment on this proposed legislation that we're discussing here? All right, Chair reflects the record should show there is none. Mr. Ramos, did you have further comment?
Going back to that case that I was talking about, where a settlement has been entered into, an order has been approved by the court, approving the settlement. And then later on, and part of that settlement is the right to lifetime medical benefits under our workers' compensation law. In that case, Representative Boyd, if an insurance company subsequently denies those medical benefits in contravention of that order, there are no further monetary benefits to gain for the attorney. So there's not 20% of anything or 30% of anything. It's a situation where an attorney won't have a further monetary award. What he's trying to get, or what he or she is trying to get, is an order directing that insurance company to comply with the order of the court for lifetime medical benefits. In that situation, an attorney has no other choice but to charge on an hourly basis, because that's not subject to the contingency fee of 20% or 30% or whatever it is. And that's the situation that I see that would easily exceed that $15,000 cap. I can tell you from personal experience it did. And that's why I still think that cap would come in to play in those cases. But as far as going beyond the sunset, I'm all in favor of that. Don't get me wrong. I'm all in favor of us extending this law.
Okay, Chair sees Representative Kelly Kiesling here today. Welcome to the Advisory Council on Workers' Compensation. Representative, I see you have guests with you. Would you like to introduce your guests?
Well, thank you.
From your district? Mm-hmm.
Glad to do that. Yes, I'll take a quick break to introduce folks from Macon County. These are folks from our Macon High, and they're here, of course, as you can tell, FFA folks.
Well, welcome to each of you to the Capitol and to that space. And you're traveling with the best in Representative Kiesling. So, all right, back to the order here. Mr. Pitts, you're recognized.
Chairman, I'd like to make a motion.
All right, sir.
Trying to be respectful to my attorney friends, the Bureau and the sponsor have spent a lot of time on this bill, and they've tried to address a number of the problems. Although it may not be 100%, it's a substantial way in the right direction. So my motion is going to be the amendment 015575, the 15 and the 30, be amended into the bill, and it move forward with positive recommendation.
Okay, you've heard the gentleman's motion. Is there a second for his motion?
Second.
All right, we have a second for the motion. Is there any discussion on the motion, which is a positive recommendation for House Bill 2154, Senate Bill 2861, with the amendment that constitutes drafting code 015575. All right.
Could I just say that I'm glad that we're moving forward with the bill, but I hope my comments are taken into consideration, because I think it's a real problem in light of the 2013 Reform Act. Most claimants are unrepresented. They just are. And that's a terrible injustice to the average working man and woman in this state. Thank you.
All right. Very good. Then we'll call the roll. If Mr. Executive Secretary, if you call the roll on the motion.
On the motion with the amendment as indicated in Bill Drafting Code 015575, on the motion for a favorable recommendation, Mr. Dove?
Aye.
Mr. Fox?
Aye.
Mr. Hunt?
Aye.
Mr. Pitts?
Aye.
And Mr. Schaefer? Motion passes.
All right, the motion is adopted, and the bill, HB 2154, Senate Bill 2861, goes out with a positive recommendation as indicated. All right, thank you very much, Chairman Boyd. All right, is there further business to come before the Advisory Council at this time? Let's see, Mr. Director, would you report on status of any other bills that may be in the pipeline to be referred, et cetera, and the possibility of future meetings?
We are, Mr. Chairman and members, the bills that were on the agenda today were referred by Chairman Boyd, and that may be the only bills referred to the council. I'm not sure about that exactly, but that's all we're aware of at this point. There were a few other bills, I think maybe 4 or 5 other bills, but most of them were not, I would say not consequential. There may be something out there I'm not sure about. Chairman.
Okay, so the bottom line situation, we don't have anything immediately right now.
There were several caption bills that were just sitting there with no amendment, and we did not refer them. And there were some that had workers' comp in them, but really had nothing to do with it, so we left them out.
All right, so we will just meet in the future at the call of the chair, and so therefore, chair makes a motion to adjourn today's meeting. Is there a second? We have a second. All those in favor signify by saying aye. Aye. Those opposed, no. The ayes have it, and the item's adopted. We are adjourned. Thank you very much, and thank you for your service to the state of Tennessee.